Of course, I have the pleasure of introducing Trish Rich. Trish is a partner at Holland and Knight. She's a nationally renowned legal ethicist. And most importantly, she's a long-serving commissioner at the Commission on Professionalism. Welcome, Trish.
Hi, welcome. Thank you for having me.
It's all yours.
Okay, thanks. Everybody can see my screen okay? All right, I am just going to change this to slideshow. Okay, so I'm a legal ethicist. I spend a lot of time thinking and writing and speaking and teaching on the ways and issues and the things that impact the legal profession and the way that it's regulated. And so obviously one of the biggest issues in the last two or so years, since last November when this really ChatGPT really hit the ground running, is how we're going to harness generative AI in the practice of law. And I think, to Damien's point, we've been using AI in the practice of law for a really long time, and we have lots and lots of applications that already use them that have been integrated in law firms of all sizes for a long time. But generative AI is a little bit of a new technology for most lawyers. I want to focus today on the ethics of generative AI technologies, and I want to start by saying that we have sort of a philosophy in legal ethics and professional responsibility law that most of these technologies, or at least I haven't seen one, that really presents a brand new problem. These are the same problems we've always seen, right? Some of the things I'm hearing today are the same things that you go back and you look at, 15 years ago, 20 years ago, people were saying about the use of emails over faxes and letters, or the use of computers even. My law firm just moved its New York office last week, and in that process, one of the things I was tickled pink to see was an internal memo that somebody had saved that was about 30 so years old, and it was from a lawyer in the firm that said, the firm had acquired its first computer, and the lawyer said, we are going down the wrong path. Nobody is going to pay lawyers to type, and computers are never going to make it in big law. And and in raising an issue as like whether or not this was going to be an ethical fee problem. And so I want to start by just telling everybody, calm down. We'll get there. This is not a new problem. This is just a new application. And so as I start talking about the ethics rules, I want you to think about it like that. It was computers, and it was phone calls, and it was fax machines, and then it was letters, and then it was emails, and these are not new problems. So starting with Rule 1.1. I teach legal ethics at NYU. I like to tell my students this rule is so important we put it first. You must provide competent representation to a client. That competent representation requires the legal knowledge, skill, thoroughness, and preparation that's reasonably necessary for the representation. That's it. That's the whole rule. However, Illinois and every state, I believe, now has adopted what we call comment number 8, which requires that in order for lawyers to maintain the requisite knowledge and skill, a lawyer should keep abreast of the changes in its law and practice, which include the benefits and the risks associated with relevant technology. So what that means, and you see this in the ethics cases, what that means is that lawyers have to understand how to use technology. And they need to understand the risks and benefits of doing that. And one of the things that's really interesting about the ethics of technology, and we're going to see this right around the corner on generative AI, is that it's quickly going to become the ethics of getting it right to the ethics of, if we don't use it, are we charging our clients too much to do something by hand that AI could step in and do? And let me give you an example of that. When I was starting to practice law in 2006, we were still doing large-scale document reviews, page by page, hand over hand, associates. My first business trip was to a salt mine underground in Kansas City, Missouri, or Kansas City, Kansas, I don't remember at this point, to go through boxes and boxes of documents that had been stored underground there. And it was right after I started practicing that we started seeing some opinions from the federal courts that said, not only should you be using computer-assisted review for large document reviews, but in fact, computers are better at it than you lawyers are. And lawyers across the country had a collective gasp, and we were like, no computer is better at finding keywords and tagging relevant documents than we are. And as it turns out, the thing that we've learned in the last 15 to 20 years is not only are computers much, much better at it, they're faster at it. And the way that that pendulum has swung, that is that if today you went out and you charged a client to review 1 million documents by hand, you're probably going to run into an unreasonable fee issue way faster than you're going to run into a technological competence issue. And that's what I expect to happen with AI. I've seen some of the comments in the chat. Yes, right now we are seeing some fake cases and some issues with AI, but it's going to get good, folks, and it's going to get good really, really, really fast. And there is going to become a point in the future where somebody is going to say, a client is going to say to us, why aren't you using a technological solution, and why are you charging me the hours and the manpower to do some of these things that technology could solve? And all of that's going to be wrapped up into this comment 8 of 1.1, because that's how technology works. It's going to get better. It's going to get better really quickly. And then we're going to be expected to have a base level understanding of how to use it, the risks of using it, and the benefits of using it. And it's going to quickly swing to a fee issue where it's, a concern if you're not properly billing clients or you're overbilling clients to do something manually that could be done by AI. But of course, 1.1 isn't the only ethics issue that we need to worry about. There's a bunch of other relevant rules. Some of them I have on this slide and I want to talk briefly about, but there's some that I can't possibly, I think, talk about all of them because the commission has asked me to limit my remarks to 15 minutes, but we'll be in the Q&A after. So some of these rules I have here on this slide. Rule 1.4, our duty to communicate with clients. One of the debates we're having right now in legal ethics is if you're going to be using generative AI tools, whether or not that's something you need to get client consent for and communicate with them, for example, in an engagement letter. No strong consensus on this yet, but it is a thing that people are talking about. But I think having, on one side of the debate, people are saying, we don't have in our engagement letter to our client, like, we're going to use email on your matter, right? But is this different and new in a way that we do need to talk to our clients about it? Confidentiality of information, rule 1.6, my favorite of the rules of professional conduct. I saw a question in the chat about this earlier. Somebody asked about whether or not, what are the implications of putting confidential client information into some of these generative AI programs. I will say, really, really, really important takeaway from this. If you are using a public chat, public GPT chat or OpenAI source to do research, do not put confidential client information into it. As I say, collecting that information is not a bug of these programs. It is the feature. It is how they work. So they will collect that information and spit it back out to other people. So it's pretty clear to me that at this point, it's a breach of confidentiality of your duties under 1.6 to put confidential information in something like that. That said, there are going to be solutions very quickly on that front. There are companies right now that are working on internal firm models, so you can have something for your law firm where you can have your own little chat GPT inside of your law firm, so it is your confidential information. And then if you are using an open program, just keep out client information. It's fine to say, what's the summary judgment standard in state court in Minnesota, or, how does the rule of perpetuities work again? Those questions are not going to get you into a 1.6 problem. But if you say, my client Coca-Cola is being sued by PepsiCo about the following thing, you're probably going to run into a problem. So if you're on an open program, be careful of that. 1.6, I think, is one of your biggest risks right now. But I think we're going to have solutions around that issue pretty quickly. Duty of candor toward the tribunal, that's rule 3.3. One of the things we've seen right now is a lot of courts coming out with these special orders saying, either don't use generative AI, or if you use it, you have to tell us. I think that those orders without being disrespectful to our friends in the judiciary, who I'm a litigator. I get that that's a tough job. I think those orders will eventually have to be clawed back. I think they're a smidge reactionary at the moment. And I'll give you the example I like to say in talks right now. The first time a lawyer walked into court drunk, we didn't see a bunch of standing orders that said you can't come to court if you're drunk. You know, we have rules in place already. And some of the cases we've seen where lawyers have gotten in trouble for some of these hallucinations or these fake cases, we already have rules to deal with that. We have Rule 137, we have Rule 11, we have rules that would have prohibited that behavior. And so I'm not a huge fan of enacting more special rules on these things. And I think ultimately we'll see sort of a pulling back of some of those special court orders. And I think that is not too far into our future. But for now, be aware of the fact that there are some courts out there that have some of these standing orders and require you to disclose or prohibit you from using generative AI altogether, and pay attention to those. Like it's like what we would tell any of our first years: know the judge, know the courtroom, know the court that you're in. Duty to supervise. Obviously, attorneys have a duty to supervise both assistants that work under them and lawyers that work under them. And so this obligation, the things I'm telling you today, the ethics rules that we have to pay attention to when we're in this brave new world, you're in charge of making sure that everybody that you supervise is following those too, from document vendors to secretaries to paralegals to associates to senior counsel. Everybody has to be on the same team. And I think there is some risk out there to law firms that the younger generations who are very comfortable with technology. I'll tell you, my students at NYU, they are using ChatGPT all day, every day for everything, and they are making it better. And so the younger generations for whom this is second nature, I think some of the older lawyers, the Gen X, and even the older millennials, and the people that are still practicing law into their aging years, really need to pay attention to the fact that these younger generations are going to be using this. It's going to be second nature, and we're responsible for their work. Unauthorized practice of law, Rule 5.5. I think there's going to be a question at some point about whether or not, some of these technologies are practicing law. I hope that answer is ultimately going to be in the negative from the bar regulators, but it wouldn't shock me to see a bar regulator pick up a case and say, like, is this practice of law? Is this computer program practicing law? And we'll see. I mean, I think we're going to see how this evolves in the next few years. Duty to exercise independent professional judgment. That's IRPC 2.1. That also is independent judgment under, independence under Rule 5.4, which isn't cited here, but is a related rule. We have seen lawyers sort of get into some hot water on using some cases that they didn't cite or they didn't properly vet. You always have the requirements in the law under the rules of professional conduct, and especially when you're in front of a court, to make sure that the work that you're doing is correct and that you're doing it independently. So those are important rules to keep in mind. There's also a risk of bias, and I think the New York Times has done just a ton of stories about bias in AI. I think that's an important thing for lawyers to be paying attention to, especially in those jurisdictions that have anti-bias rules in their rules of professional conduct. And then, of course, there's a risk of violating IP law. Again, a feature and not a bug of some of these systems is that it collects information from everywhere, and that information in some cases is protected by other statutes and protections and laws. And I think we need to pay attention to, if we put something in a brief, who wrote that and do they own it? And am I plagiarizing, or am I infringing on somebody's IP rights? And I think lawyers need to be paying attention to that too. There are a number of other rules. I think, as Damien mentioned about fees, I think it's going to be really interesting. I also don't think this is going to kill the billable hour, but I think it will make some routine, mundane tasks more readily available to be moved to like an hourly billing structure, or not, a flat fee billing structure, or a project billing structure, or maybe even a subscription billing structure. I think we'll see some of that as we continue to work through AI. There's going to be, it is as I started, I'm short on time now, so I'm going to wrap this up so we can get into our group session. But I think there is a sense, as I said, that this is a brand new problem. I don't think these are brand new problems. It's a new application of the same ethics rules we've always seen. I think it's going to be a really exciting time to be a lawyer. And I think we're going to see some guidance from the bars in the next couple of years. And I'm really looking forward to it.